What I'm going to tell you today is likely going to surprise you, and that is because it will make sound slightly overstated all that you heard recently about Brexit, meaning no longer access to Europe and European investors for UK investment firms. In today's video, we will talk about the concept of tied agents under the MiFID directive. We will see what they are and we will compare them to the UK version of the appointed representative. We will also see what ESMA thinks of the way tied agents under MiFID have been used recently by UK investment firms, and we will also see how to make sure that we can stay in line with what ESMA suggests its briefing. Before I go on, I wanted to ask you a question. What is that you want to do with Europe? Do you want to distribute collective investment schemes, or do you want to offer other type of investment services? The MiFID tied agent solution suit better a situation where you want to offer collective investment schemes, and for anything else there might be other solutions that might be more suitable. As the term suggests, a tied agent is an agent, in this case, of a MiFID investment firm, which we will define as principal firm for the sake of this video. A tied agent can be a natural person or a legal person. It can be domiciled in the same member state where principal firm is located or in a different member state in Europe. The tied agent is tied to the principal firm. It works exclusively on behalf of one principal firm only. The principal firm is responsible for the acts of the tied agent, and so the tied agent does not need to get an authorization to carry out investment services or activities because it will derive its permission from the principal firm. What was the main use case for MiFID tied agents in the past? For example, insurance firms, be it brokers or insurers, would hire tied agents to boost their presence in certain markets and increase their sales. With Brexit, UK investment firms have seen in the tied agent arrangement one way to retain access to European markets and investors, and more namely becoming a tied agent of a European principal firm. The reason why ESMA decided to step into this arena and set the standard for the appointment of MiFID tied agent is because UK investment firms interpreted the concept of MiFID tied agents more closely to what the UK appointed representative concept is. And for us to understand what ESMA didn't like about it, we should look briefly at what an UK appointed representative is and what it can do. In the Financial Services and Market Acts, the appointed representative, which remains also a tied agent, is designed essentially as an exemption to the main prohibition, whereby if you're not authorized to carry out an investment service or activity, you are prohibited to do so. An appointed representative enters into an agreement with a principal firm, derives from the firm its ability to operate by virtue of this agreement under an exemption, and is allowed to carry out its activities and its services, provided that it respects the provisions of the agreement with the principal firm and can pass also the ongoing monitoring and supervision carried out by the principal firm. There is an essential difference between the UK appointed representative and the MiFID tied agent. The appointed representative, for being an exemption, has a less stringent relationship with the MiFID principal firm. The appointed representative is its own entity and doesn't need necessarily to work on behalf of the principal firm. Different is the concept of MiFID tied agent if we want to interpret it very strictly to the letter of the provision as ESMA wanted to do, because the tied agent has to act on behalf of one MiFID principal firm. And so ESMA identified in the use case of tied agent by UK investment firms that these firms were adopting a less stringent approach on tied agent, which wasn't aligned fully to the provisions contained under MiFID. One of the first issues that ESMA identified was that many UK investment firms using these tied agent arrangements might have been continuing to carry out their activities sitting in London, sitting in Mayfair or in the city, and by virtue of being tied agents of European principal firms, acting as if Brexit had not happened. And so in order to avoid that there was a full or clear circumvention of the loss of passporting rights, ESMA has required that tied agents have substance in the domicile where they are established. So if you want to set up as a tied agent of principal firm, for argument's sake, in the Netherlands or in Austria, you have to have a company there, and substance means by and large that you have a local director, that you have local employees, and that you have an office space, whether shared or not. That depends largely on the approach that various states take in Europe on this governance and corporate law issues. The other requirement that ESMA wanted to impose or highlight with this briefing is that MiFID tied agent, they have to act on behalf of a principal firm. And so, to the contrary of a UK appointed representative, which can be independent in its activities, the MiFID tied agent has to introduce itself to clients as being part of the MiFID principal firms it represents. And this approach has various implications. For instance, there will be use of emails from the principal firm and not from the promoter of the engine or the mind behind the tied agent, which might be based in the UK, for instance, and being a different company. In certain instances, there are other implications. For instance, agreement with the investors or with the end client should be between the principal firm and the client rather than the tied agent and the client. The approach of ESMA on the tied agent has been tightening what was a more relaxed take on this concept, which was also closer to the appointed representative than it was to the original version of the provisions. And this approach had already repercussion on the growth of this leasing model for MiFID investment services in Europe. We know that in Europe a leasing model has flourished for what concerns fund management, and we know that if you want to lease a license for fund management, there are certain domiciles where you can go and do that, where the standard is a standard of excellence, and that is either Luxembourg or Ireland. For what concerns the leasing model of MiFID investment services, we haven't seen the same growth so far, and partly that is due to this position from ESMA, very restrictive, which puts some pressure on the few providers that we have today of these services. There are specific domiciles in Europe, however, where it is possible to find firms that can offer this tied agent arrangements, and those are not the domiciles that you may think. Those are domiciles that are a little bit more niche, where there was mostly local capital in the past, and that are opening themselves to the provision of this leasing model for investment services. And this is also thanking to the fact that the local supervisory authorities have demonstrated openness for these activities in a way to attract capital from outside. Given the constraints that ESMA has put in this environment with its supervisory briefing, MiFID principal firms in Europe are becoming more picky. They can decide which firm they want to work with, and they can also dictate the price. And so for you to be successful in seducing these firms in working with you, you will have to be, of course, of very high standard. Likely you will have to be interested in distributing collective investment schemes out of Europe. Tends to be a little bit more difficult if you want to offer investment services, and there is something that you have to bring to the table in terms of language skills, in terms of penetration in certain markets. And that is because MiFID principal firms in Europe will have to justify in their business plan why they need one more tied agent, which is one of the other requests from ESMA, which also puts pressure on the evolution of this model in Europe, because how many tied agents are too many for a MiFID principal firm. And so the more you can bring skills to the table, the more you can give experience and penetration in certain markets, the more appealing you will become in the eyes of a MiFID principal firm. There is more to come on European regulation. I wanted to thank you for having watched this video. Please subscribe to the channel and hit the like button. Stay tuned.